Thanks that you all came. It's really nice to see that also these small rooms get really full this year. And I'm very happy to welcome you to the panel on automated processing, which is actually organized by the Fordham University Center on Law and Information Policy. You might miss Reidenberg, actually. Unfortunately, he is sick and we had to replace him. So my name is Ann-Katrin Habbig. I'm from the VUB itself and trying to chair this panel today. And I would first like to give you a very short overview before I introduce the speakers. In general, when you're using websites or apps, you're very often asked for consent. But do you really take the time to read them? And if you read them, do you actually understand them? So I actually hope that we have a round of experts here and you are able to understand the privacy policies. But if you understand them, would all in the room agree on what they mean? And actually, would your family be able to understand them, for example, the people who are not experts? So it is often said that online privacy policies are the pillar of the consent model for the protection of individuals. But we see very often that the website privacy notices are actually very confusing and therefore ineffective for users. So today we want to discuss if there's a technical solution for this problem. And then within this project that's presenting this panel today, there have been experiments and that show that automatic or semi-automatic language processing may be a solution here. And these technologies actually can extract the meaning of the terms from website policies and then convert those terms to an understandable information, which then is meaningful for users, but also for enforcement agencies. So we want to talk about the limitations, but also about the opportunities of these technologies today. And I'm very happy also to welcome Solon Barakas today. He's the moderator of this panel, and he's a postdoctoral research associate at the Princeton Center on Information Technology Policy. And his research mainly focuses on emerging applications of machine learning and also on ethical issues that they raise. Our first speaker will be Florian Schaub, who's a postdoctoral fellow in the School of Computer Science at Carnegie Mellon University. And actually it's very interesting to have you here because his research really focuses on the human factors of privacy, specifically the usable and context-adaptive privacy mechanisms, and then he works on the semi-automatic extraction of data practices. So he will explain the technology to you, I hope, at least. We also have Mr. Alexander Dix, who was elected the Commissioner for Data Protection and Freedom of Information in Berlin, that's the state of Germany, in June 2005. Before, he has already been the Commissioner of Brandenburg, the state around Germany, the state around Berlin in Germany, and he actually has 28 years of experience in privacy and data protection. Then we have Gwendal Legrand, who's the Director of Technology and Innovation at the French Data Protection Authority, CNIL, where he supervises the IT Experts Department, the IT Operations Department, and the Innovation and Foresight Unit and the CNIL Labs. And which is also interesting for most people here is that he's actually participating in the activities of the Article 29 working group. Then we have Aaron Burstein, who's an attorney advisor to Commissioner Julie Brill, and has been a policy advisor for the US Department of Commerce, and also a director for privacy and civil liberties at the National Security Staff of the White House. And then the final person, last but not least, is Cameron Russell, who's the executive director of the Center on Law and Information Policy, CLIP, at Fordham Law School in New York. And he conducts research and facilitates high-level public discourse with this center on topics such as data privacy and security, peer-to-peer technologies, and also intellectual property protection. So I'm very, very happy that you're all here. I would like to give the word to Florian Schaub. We keep the presentation short. We will have some discussion afterwards, moderated by Solon. So please discuss amongst each other, and we are also open to questions. Thank you.
right. Thanks for the introduction. I'm just going to give you a short overview of what we're doing in terms of semi-automatic extraction of data practices from privacy policies. And this is part of the Usable Privacy Policy Project, which is one of 3 frontier projects founded by the National Science Foundation in the Secure and Trustworthy Cyberspace program. And it brings together a really multidisciplinary, interdisciplinary group of researchers, including social scientists, researchers from different sub-disciplines of computer science, and legal scholars as well, and from 3 different universities in the US. So our goal is, given these long privacy policies of websites no one reads, we all know the problems, to move to a more effective privacy notices that are shorter and more usable and more understandable for users. And the way we're approaching this is by combining crowdsourcing, natural language processing, which is a computer science extraction technique for documents, and machine learning to basically extract data practices that are relevant in those policies, and then use those to create more effective notices. Okay. In order to do this, we started building a set of privacy policy annotation tools, and the idea of these tools is that we ask crowd workers questions about policies, ask them to annotate certain parts of policies in order to identify data practices in these policies and involved information types. And typically when you do crowdsourcing, which means these are small tasks that go on platforms like Amazon Mechanical Turk, and people complete these tasks for a small fee to make money, you show the same task to multiple crowd workers to see do they actually agree on these annotations, and this way we can reduce some of the uncertainty. Doing this, there's a question, how good are crowd workers at actually understanding these policies? And we conducted a couple of experiments and studies where we looked at this, and what we find is that crowd workers can actually be quite effective at interpreting the privacy policies, and in some circumstances they are comparable to policy experts, but there's also quite some variation. It really depends on the data practices you're looking at. When we talk about collection of data, it's usually very easy to extract that. Crowd workers find that. So think about collecting contact information, aspects like that. But other aspects like third-party sharing are harder to extract because the information is often spread out throughout the policy rather than in a clear labeled paragraph. So that's a big challenge we're currently addressing and working on. And the other aspect is that a lot of the language in policies is very ambiguous. And that is often on purpose. And you have to deal with very broad purpose definitions and aspects like that. So this is another research question we're looking at the moment. And then what we eventually want to achieve is to move towards automated extraction. So at the moment we're paying crowd workers to do this, but the idea is to use this information that we obtain from crowd workers and as well as from expert annotations to train classifiers and build machine learning models to then detect common phrases in these policies that describe a certain data practice or describe a certain information type. You would think there are only like a limited number of ways how you can refer to contact information. It's actually a lot more than we originally thought. And these machine learning results we then use to either automatically extract certain types of information. We're already getting quite good at extracting, for example, the collection of contact information statements. But in cases where we are not that good yet, we can also use these techniques to support crowd workers in being more efficient. And one way we're doing this is we're building models of relevance models of text to predict which paragraphs likely hold information about a certain data practice, for example, in this case, collection of financial information, and then highlight these parts of the policy so that the crowd workers don't have to read the whole policy necessarily to answer the question. And then a big goal of ours is to actually really scale up this analysis. So we don't just want to annotate 10, 20, 50 policies. We want to be able to scale this approach to annotate hundreds, maybe thousands of websites' policies to actually be meaningful. And the way we want to achieve this is by really combining machine learning and crowdsourcing to really reduce the number of tasks we have to give to crowd workers and pay money for and answer as much as we can automatically. And at the same time, we're also looking at building volunteering platforms where interested citizens and users can contribute to this effort and help us with their annotations. And another aspect is, instead of trying to extract everything out of the policy, we're currently really focusing on practices we think are relevant, are critical, and would likely be interesting for users. So I'm really looking forward to the discussion later and hope that we get some insights also what you think might be critical data practices we should be looking at and should extract. And we think this approach really holds potential for large-scale analysis of these privacy policies. So there have been these privacy policy sweeps where basically regulators look at a certain set of policies, and you might be able to do dozens, maybe 100 policies this way. We hope we can do this on a large scale, so that you can really compare 100 shopping websites' privacy policies and 100 news websites' policies and these kind of things, and determine which are the better players in the space in terms of privacy. And the other aspect is that we want to use this information to really help users better understand what they're getting into and warn them about issues that might violate their expectations. Yesterday there was a very interesting panel talking about consent and control, and one of the points was that users usually expect that certain information is being collected in the transaction they're engaging in. When I order something from Amazon or another shopping website, I'm quite aware that I'm giving them my address and my credit card data, and there's a certain purpose for that. But I definitely don't expect that they sell this information or hand it over to data brokers necessarily. So these are the practices we really want to focus on and warn about. And we're building on, in order to do this, we are looking at the usability of existing tools, plugins for browsers, as well as nutrition label approaches that have been proposed by some of our colleagues. And one aspect we're also looking at is a relative comparison, basically telling you which other websites maybe do better in this space than the one you're currently visiting. And we have experimented with something like that in terms of the financial industry, where members of our team extracted information from financial privacy notices and built a website with, I think, over 6,000 financial institutions in the US that basically help you also rank relatively how well do they do in these aspects. And we plan to extrapolate that to general websites. So the takeaways of this project is really we're trying to extract data practices from privacy policies, and we're doing it with a combination of crowdsourcing and machine learning. So we're using human intelligence and machine intelligence in combination to get where we want to get quicker. And we think this holds potential for large-scale analysis, and as well as providing notices that are more relevant and usable. And with that, I hand it back to Solon.
Great, thanks very much. If I understood correctly, I think we'll have the rest of the panelists maybe make an introductory statement of some sort. Is that right? Yes. Okay, and I think the order then also was that Cameron might go first to kind of reflect on some of the limitations, possibly from a legal perspective.
So as Florian mentioned, we're attempting to use the automated tools to improve notice and choice, but of course, any tools we develop will be limited by the limitations of notice and choice as a regime. So this morning, I want to very briefly touch on 2 points. First, some potential legal limitations with regard to use of automated tools in the notice and choice regime, as well as then the potential for spinning a presumed limitation, ambiguity and vagueness into a potential tool for industry and also regulators with automated processing. So ways that automated processing may assist to identify ambiguities in drafting of privacy policies and online notices, and ambiguities in legal interpretation of those notices. So first, limitations of a notice and choice regime. We're all aware there are many criticisms of notice and choice as use as a governance tool. But the tools we develop, as I mentioned, will still be limited by the inherent limitations of notice and choice as a regime generally. So if notice and choice doesn't effectively address certain perceived privacy harms perceived by website users, then the automated tools we develop, the techniques we develop, cannot remedy these deficiencies. So, for example, the notice and choice framework can, in theory, work to prevent unauthorized disclosures and surreptitious collection. An adequate and sufficient advance notice, a meaningful choice given to users, provides them with autonomy and control over their info. And accurate and detailed descriptions of data sharing policies provide meaningful choice as to whether to authorize disclosure. Transparent data collection policies provide meaningful consent as to all methods of collection and all data collected. So the notice and choice framework can remedy these privacy harms ex ante with meaningful choice. And likewise, notice and choice can work to remedy unlawful retention harms, but only if durational specificity is stated in the notice, only if there's meaningful choice as to the duration of the retention. However, research, we surveyed litigation, class action litigation in the United States, as well as FTC enforcement actions, and we identified that there are outer boundaries where society deems certain practices unacceptable, shown through the bringing of a class action lawsuit or the bringing of an action by the FTC despite notice. So in essence, there are objective standards that cannot be disclaimed through advance notice. So automated processing tools would still leave these aspects unresolved. Specifically, inadequate security in fact cannot be negated through advance notice. General statements like we protect your data, we keep your information secure, we comply with industry standards are irrelevant to the harm caused, a failure in fact to secure. And notice and automated tools that improve notice that cannot negate negligent, objectively wrongful security practices. So in addition, litigation that we surveyed indicates the public expects data retention periods to be limited to the period that's reasonably required by the company's business need. So to the extent that users perceive this as a privacy harm, this wrongful retention is also not capable of redress in the notice and choice regime. So this objective duration standard cannot be disclaimed through advance notice. Vagueness or permissiveness also do not provide users with meaningful choice. And in this regard, vagueness as to data retention policies without specificity cannot be addressed through our automated tools. Lastly, notice and choice, and we found through the FTC enforcement actions in particular, in part of their statutory mandate to regulate unfair commercial practices. So notice and choice can't legitimize practices which are inherently unfair. So perhaps the privacy notice can negate deceptiveness, but not unfairness, which has also been an objective baseline standard that cannot be negated through contract. So even with these automated processing tools, there are some gaps that would still need to be filled because notice and choice leaves these areas unfilled. And so this leads me in my last couple of minutes to vagueness and ambiguity, which I said from the outset may be something that's a perceived limitation of the automated tools, but maybe we can use our automated tools to provide something for industry and for regulators to utilize to identify ambiguity and vagueness. So we had different interpretations in our research by crowd workers, by knowledgeable readers, and yes, we had ambiguity, different interpretations by expert privacy scholars. So, however, we're hopeful that the automated tools can assist to identify the ambiguity and use natural language processing, as Florian explained, to develop a dictionary of vague terms and perhaps poorly drafted language in specific areas and things that people cannot uniformly interpret. So, in essence, a type of empirical evidence as to ambiguity or vagueness. And so there would be automated recognition of this ambiguity, and then perhaps we can generate a numeric score for ambiguity of particular notices on the web, measure ambiguity, and perhaps industry by industry. And at a minimum, that would give industry a mechanism to improve the drafting of their privacy policies and online notices. But we'd very much like to hear the perspective of the regulators as to whether this would be useful and how it would be useful in their roles. And if so, how we could put it in a package that would be most useful to them.
Excellent. So I think we actually might hear a little bit about that right now, and maybe we'll just go down the panel, starting from your right, Cameron.
Thank you and good afternoon. I'm Aaron Burstein from the Federal Trade Commission in the United States. Let me just zoom out a little bit and explain how the FTC enforces privacy and data security. We do it primarily, as Cameron said, through our authority to stop unfair or deceptive acts or practices. We've brought probably 4 dozen or so privacy cases over the last decade using that authority, and have used deception as the basis for enforcement in probably the majority of those cases. So it's through that lens that I think it's most helpful for me to reflect on some of what has been said already this morning. I think one important thing to clarify about deception is that we have a fairly well-developed doctrine that defines what a deceptive practice is. It has to be some sort of representation or omission that is likely to mislead a consumer acting reasonably. And that representation or omission has to be material. That is likely to affect a consumer's decision to use a product or how they will use the product. And those elements are important to keep in mind. So let me first address some of the focus of automated processing and the focus on ambiguity or vagueness in terms. That certainly can be the basis for bringing an enforcement action using deception, but there are other ways to do it, and I think one question that I have and hope we can discuss here is whether this sort of automated approach is capable of capturing things. Other ways of enforcing deception are through an omission, and we have brought cases where an app, for example, was collecting precise geolocation information. All this app did was activate the light on a phone to turn it into a flashlight, and in the privacy policies and other sort of advertising material for the apps, it said nothing about this. We alleged that that omission was deceptive because it was certainly something that consumers would have wanted to know about the app before they installed and used it. So omissions are important, and then outright inaccuracies or false statements are also very important. That, it seems to me, requires knowing not only what's in the policy, but what's actually going on with respect to an app and how it's collecting data, how it's using data. So I think it requires some marrying of the policy with how things work in practice. So that's I think some of the questions that come up with respect to actual law enforcement, suing companies for potentially deceptive acts. But there are a lot of other things that the FTC does that don't require such a deep dive into specific practices, and where I think there seems to be a lot of promise for a large-scale automated approach. One thing that we've done in the past is to do surveys of apps, and I wasn't part of the team that did these. I'm sure that the attorneys and analysts who did them would have loved some sort of automated tool that could help narrow things down. The scale that we could do these analyses on was, I think, in the hundreds of apps, and certainly being able to get a broader picture could be very, very useful. Could inform best practices, and as sort of an intermediate step, might also provide the basis for warning letters to companies where we can publicly say to 10 or 12 vendors, it looks like you have a problem and we think you should fix it, and that can often be effective in getting attention. So there are other ways that the FTC works through policy development and best practices development that I think could really take advantage of this approach. And then just one final note is that we also think a lot about how to improve practices from the perspective of consumers. And as we move toward a world of connected devices, things without user interfaces, one thing that we're thinking about a lot is how to still present information about data practices to consumers before they buy a device or reach the point of no return of setting something up and they own it, they can't return it. So it seems to me that maybe having the automated approach combined with some better way of presenting information about the terms in a privacy policy that consumers could access before making a purchase, before going to a store, for example, and buying something, that would be very useful and would address what I think is really a significant challenge as connected devices become more common.
Okay, so hello everybody. I'm Gwendol Legrand from the French Data Protection Authority. We had a look at the ideas behind this concept of automated processing of the privacy policies and practices, and I think in general it's something that can be very useful for various reasons and various people, and this is why I'm going to elaborate on during my brief intervention here. And there's also some limitations. So basically what I'm going to present is what my understanding of how this can be useful for users, for regulators, and for the companies themselves. There are processing personal data, and in each case, a number of limitations. In a way, if I want to simplify this tool, what I understand from it, it's you have practices out there, people comment on the practices with some kind of closed questions, and then there's an automated processing of the comments, which is a bit similar to TripAdvisor to a certain extent, if we which is a good thing. It's working pretty well, so I hope for you that you're just as successful as TripAdvisor. But the idea is more or less the same. You have a product out there, people, crowdsourcers are assessing the product, and then there is processing by the system to tell you whether or not the practices by the products that are being assessed by the crowdsourcers are good or not. So obviously this type of thing is useful for users because they can get a better understanding of what is going on in the systems that are being analyzed. It provides some space for discussion on the different products and services. And maybe also it can help to go towards a better standardization of the way the information is being presented, because people will be looking at this tool, they will see what is understood by users, what is not understood, what is not clear. So hopefully it can be an incentive for companies to present the information in a way which is clear, complete, and understandable by the public. I see maybe two limitations with respect to users. The first one is that it's hard to understand the real practices of a company based only on the privacy policy itself. I mean, Florian and Cameron have already elaborated a little bit on this, but we've seen this also as regulators when we investigated into the privacy policies of big internet players, for instance. Even people who are well aware of the privacy law and things like that, when you look into the privacy policies of a certain number of big internet players, it's awfully difficult to understand what they do. To find all the information which is actually scattered in many different documents, and not only in one single, the ideal case is you have one privacy policy and people are commenting the privacy policy. But today you have in-product notices, you have sometimes for some companies, and this is an approach that is recommended by the Article 29 Working Party, layered privacy policies and things like that. And I don't know to what extent the system could actually gather all this information to get a full picture of the information provided to the users. The other drawback maybe or limitation is the fact that as in TripAdvisor, I mean, you can have people who are deliberately doing wrong statements or comments about a product or service. So I don't know to what extent you can mitigate this type of bad behavior by the crowdsourcers or unfair behavior by the crowdsourcers, and I think this maybe is a possible limitation. So maybe the answer to this is if you have many people providing comments, then you know it's like in mathematics. At some point you converge and you have more certainty in the result. For the regulators, I think the tool can be very useful too. Well, it's not a complete tool for enforcement, for sure. I mean, this was already very well explained by Aaron. When a regulator investigates into the privacy policies of a company, they have to look into many things. Information is one of those things, and there's also the actual retention periods, and I think it's difficult to do automated processing to determine whether or not the retention period is adequate with respect to the purposes. So it's a tool that can be useful for us to maybe target our activity in a more relevant way. It gives us some information to decide what companies we should be looking into, and I think this is very relevant in the context we have today, for instance, in a number of regulators in Europe, because we're developing online inspections. You know, we've done a cookie sweep also at the Article 29 level. So we look into the practices of many companies. We have automated tools to see how many cookies they're placing, and a number of things that you can analyze automatically. And then you need to go to have some human analysis if you want to, you know, completely understand what the company is doing. Also for the regulator, and this was already also touched upon by Aaron, in any case in Europe, the compliance with the data protection law is not merely about respecting what is in the terms of service. I mean, you can claim whatever you want in the terms of service. It's not a way to get away with the data protection rules that you have in the European framework. So we're not just looking into unfair and deceptive practices, and there's a concrete example in Europe right now, because many authorities are enforcing with respect to Google on their privacy policy since a couple of years already. And I know the FTC has also had some action with respect to Google. This was before European regulators, and they investigated Google Buzz, basically, when they launched Google Buzz on the basis of the unfair and deceptive practices, because Google didn't say that they could use the fact that you were using Gmail to register you automatically into new service, which was Google Buzz. So actually the approach is a bit different, and today in Europe, with the current data protection law, with the current privacy policies of certain stakeholders, we can enforce. Last point is maybe for the companies themselves. Well, it's clear now since last year at least, and the Google Spain case, Google Spain case versus the Spanish DPA, that US-based companies will need to adapt to the European law and rules and national laws. So they have to align their practices on a level of protection which is compatible with what we have in the European legal framework. So I think that the tool can be useful to find the right information notices that you would put in the system. I know that in the mobile environment, there's already systems like this where when you call a specific API, they propose a specific information notice that you can put to explain what your app is actually doing. So maybe you can build on this idea to encourage more standardization in the way the information is being presented to the users. And maybe the limitation with respect to, well, it's maybe a more global limitation, is the fact that privacy practices and privacy policies tend to change very frequently today. And when a company changes the privacy policy, if you rely on the crowdsourcers to assess the privacy policy, you will maybe need to restart from scratch because there may be very significant changes in the privacy policy. So that's maybe something to be taken into account. But overall, I think it's a very useful tool that can be used by many different stakeholders in the environment. Thank you.
Thank you. I'm Alexander Dix speaking last. I'm in the comfortable position just to refer to the speakers who have said a lot of very pertinent things, but just let me add a couple of comments. Maybe I start with a famous quotation by Joseph Weizenbaum, who has said, automated processing of data doesn't solve problems, it simply automatizes them. So I'm not quite as skeptical as Weizenbaum, and therefore I agree that this is a very interesting tool and research project. I should remind you, as Gwendal already has done in passing, that the international community of data protection commissioners has addressed the issue of information policies, data protection policies way back in 2003. If you look at working paper 100 of the Article 29 Working Party on Harmonized Information Policies, you see a reference to a document called the Berlin Memorandum on Privacy Notices, and there we tried to address the issue of multi-layered information policies. The internet offers great possibilities to simplify information notices. You don't have to flood users with loads of legalese up front when they call up the privacy policy. You can start with an icon, and if someone wants to learn a little bit more about the privacy policy, he can get a condensed notice on information practices, and if he is still not satisfied, he can look at the full text. So this idea of layered, multi-layered information notices is quite old. Some companies have adopted them, but now in the mobile era, with apps and all that, we need something more sophisticated, and therefore I think this approach Florian has presented is can be very helpful, keeping in mind the limitations mentioned by Cameron of the notice and choice regime as such. There are big differences between the US approach on notice and choice on one hand and the European framework. Wendell has referred to that. And as a regulator, I would always ask web service providers and indeed controllers, do they actually do what they say they do? First question. And second is, do they do something without saying or even denying it? And there it was interesting to listen to Aaron's comments that the FTC is considering omission of information as deceptive practice. That's a very important point, but still you need some kind of evidence what is happening in real life. You need, before a German court, you would need hard evidence that a company is doing something, and therefore you, in the end, any regulator has to go out and look into the back office or look onto the service, what is happening actually. But still, the tool Florian has described is an important element, could become an important element in any enforcement or auditing strategy of any European regulator, having in mind the limitations that have been pointed out. So, thank you.
Excellent. That I thought was a fantastic response to this early presentation by Florian. And I actually wonder if I could ask you, Florian, if you would take maybe another minute or two to clarify the kind of technical mechanisms at work here, because certainly part of it is crowdsourcing, but there's an additional element which I think is even more important, which is the automation of the analysis using machine learning and natural language processing. And I get the impression based on the comments that that part may not be so clear. And so if you could talk a little bit more about that, I think that would be helpful.
About the automation part?
The natural language processing and machine learning part, so going from crowdsourcing training examples to.
All right. There were some quite interesting issues raised and mentioned. Let's maybe look at the crowdsourcing first shortly, and then we move to the automation aspect. Concerning the quality of the annotations, like do crowd workers lie and so forth, the way we control for that is by having multiple crowd workers presenting the same task to multiple crowd workers. So if there's high agreement between different crowd workers, we can assume with high confidence that that's probably the interpretation that makes sense. We can also basically monitor the performance of individual crowd workers across different tasks. So when they come back to our tool, we can re-identify them and can link their annotations and see how they're performing over time. So at some point we might decide not to show them more tasks if they're underperforming or always basically answering away from the majority. So these are some of the strategies we use. Changing the majority may be wrong sometimes. That's also an issue. Although what we found is in most cases, so we ran a study where we compared annotations by crowd workers and policy experts, and what we found is then that when the policy, either the crowd workers agreed kind of on the same interpretation as the experts, or they did not agree at all. So that means when it gets more complex, the experts are better at finding the actual interpretation and maybe agreeing on an interpretation, whereas the crowd workers are just all over the place and don't know what to make of this. Concerning the annotation, the automation and the natural language processing. So the way this works is that we gather ground truth data, basically. We have experts annotate policies, highlight text, explain what that means, and we have crowd workers do the same. We compare the quality between these different data sets, and this way get ground truth data we can use to train machine learning models. And what these models do is they basically look for similar patterns across different documents. So collection of contact information is described in a certain way, and there might be variations how this is described across websites, but there are certain similarities, and the more data we have, the better these models get at detecting these the variety in the text, basically, and still understanding, okay, this is collection of contact information. So that's roughly how it works.
Yeah, I mean, the one thing I would maybe add is to say that the point of doing the crowd work is to be able to develop a training set, which will then help you build a model. And then the way to scale is to use machine learning and natural language processing. So is that a fair description?
Yeah, that's a fair description. And we're also going a step further. So it's not just that we use the crowdsourcing to basically bootstrap our models for machine learning. We can also use crowdsourcing to validate our models again. So basically, we might have automated algorithms that say, oh, this policy or this paragraph states data is shared with third parties. And then we can show it to crowd workers and ask them, is that actually the case? So we can turn it around, and this helps us to get also better interpretation for these more complex data practices that might be hard to interpret by the crowd workers without any cues, but when you tell them, is this true about the paragraph, it might make it easier for them.
Great, thanks. So I wonder if we can have a discussion about the facets of the policy that we should be monitoring. And it seems that the work that you've done already, Florian, and the larger group, has been kind of looking at FTC actions and class action lawsuits, and from that kind of inductively inferring a set of issues which you perceive as being the most salient for consumers. And that certainly seems to be one way of doing it, but I wonder if there are other ways of doing it that would be more useful or appropriate for different audiences. So if this was being designed for regulators to use rather than for consumers, what are the facets that we should be focusing on? And this to me seems like a really crucial question about the kind of most basic thing you have to establish from the start. So it'd be great to hear a kind of variety of perspectives on that. And anyone can take that question.
Just to clarify, are you asking about are there specific types of data or
yeah, so how do you change the narrative policy into discrete elements that you code, and how do we determine what those discrete elements will be?
So from the FTC's perspective, I think that one of the top issues for us in looking at privacy policies now is whether they are making accurate representations about particularly sensitive data. So for us in recent years, apps designed for kids, apps dealing with health information, apps dealing with precise geolocation information. Those have all been areas of major focus for us. So I think that if one were looking to fine-tune a coding system or to train models, then those are particularly important representations. If you look back at the FTC enforcement and policy record over the past few years, so that would be my initial suggestion. Interested in what others have to say.
If I could just clarify a little bit. So when we started, we had a methodology as to how we selected what the important, what harms seemed important to users, and we boiled down the essence of the claims. So the claims made in the class action and the claims in FTC actions. So we didn't kind of pull them out of thin air. We kind of articulated what actual users, what was important to actual users, so important that they would sue about. What's important to regulators, so important they bring an action to remedy. And so we boiled it down to general categories, but of course I think the nuances of the technologies and the nuances of the industries will be important as well.
I think it's a difficult question. I will try to make a simple answer to a difficult question. As far as the regulator is concerned, I think we enforce on the basis of the law. So if you look at the European law, there's a list of items of information that have to be provided by a data controller when there's personal data that is being processed. This is Article 10 of the European Directive. You have information on the identity of the controller, on the purposes of the processing, information on the recipients or categories of recipients of the data, whether you have obligatory or voluntary replies to questions that are being asked, as well as the consequences of failures to reply, the existence of the rights of the persons and how people can exercise their rights. So that's, I would say, probably the legal answer. Then you need also to have clear and complete information, because in the law you qualify the quality of the information. If you look into what we've done, for instance, concerning the privacy policy of major internet players, there was a letter by the Article 29 Working Party that was published in October 2012 concerning the Google privacy policy, and basically what we say in there is after several months of investigations by the regulators, we still didn't know exactly what they were doing in the system, and one of the conclusions was, well, either the information is clear and complete and so on and so forth, but then the purposes are not clearly defined, or the other solution is the purposes are clearly defined, but then and therefore they're vague, but then the information is unclear. So that was one of the conclusions that we had in the letter. So basically, quality of the information has to be understandable. You need to adapt the information to the level of expertise of the person you're talking to, and this relates to the questions of their layered privacy policies, the fact that you can have a very general privacy policy, and for people who are more experts, more detailed, and there's different ways of presenting this information. You also have a lot of people presenting in-product notices. How do you make this automated processing of all of this? Because the in-product notice actually depends on where you are in the system and how you're interacting with the system. Otherwise, you don't see this notice. So that's very tricky, actually. And then the fact that we have very different interfaces. So we touched upon this very briefly, but when I'm using an internet service today, I may access this internet service either using my laptop with a big screen, or using my smartphone with a small screen, sometimes with information which is not the same, even though the service in the back end is the same. So how do you adapt to this? How do you make sure that there's the same quality level of information regardless of the way you access the information? How you adapt the quality of the information to the user, and check that you actually stick to the requirements that are in the law, and that the information that needs to be provided to the user, and this is non-negotiable in Europe.
Just a short additional comment. I would like to compare this project with a famous attempt to achieve machine-readable privacy policies in the past, where Laurie Craner, who's also engaged in this project, was very prominent. That was the platform for privacy preferences. This attempt failed because it relied and it needed the cooperation of website providers and browser manufacturers, in fact. They didn't actually, in the majority, went along with this attempt, and therefore what we need and what I hope from this research may come out is a tool which is independent of the cooperation of service providers, which can actually remotely look at the privacy policies. German regulators are already using these tools, some tools for remote auditing as a first step to investigate in the practices of a company, of a controller. And therefore, I very much like the suggestion by Cameron to arrive at some kind, I think it was Cameron who said that we could arrive at some kind of automated recognition and even ranking or scoring of the degree of ambiguity. So if we could have some kind of traffic light system, maybe something of this sort, where not only the regulators but also the users could easily detect which privacy policies they better stay away from, or which services and offers they better stay away from, because they're too ambiguous, or they really don't come up front, and never mind the actual practices, if they come up with insufficient privacy policies.
So, I mean, one way to think about this is to kind of see it as there being potentially a trade-off between technical specificity about what is actually happening in the corporation and making those practices easily understandable in a kind of dashboard or icon or nutrition label format. But it seems to me that perhaps these tools could do both things. There's a possibility here to kind of present certain kind of information to the user and present very different information to a regulator or to the company itself. And I wonder if that's something that's already happening. Will this be the kind of work that happens across multiple teams, or is this something that could be kind of undertaken through the same team? I don't know, Florian, maybe you have a thought about this.
Yeah, these both aspects you mentioned are clearly our motivation for the project, and I agree there should probably be different representations for the users and for the regulators to work with. Our focus at the moment is a little bit on helping the users to understand what's happening, because it's something that's really lacking. But I think, especially the input we're getting here, and also in the future, if you have any ideas, please contact us. Would be interesting to really build tools that also help regulators, and not only regulators, but also the scholars and researchers that are interested in looking at these policies and finding deficiencies or good practices. I mean, we not only always have to look for bad things, we can also highlight the good practices. So that could be an interesting aspect as well.
I'm going to ask one follow-up question, and then we'll open it up to the audience. And this is actually about research. And so I wonder if these tools could also reveal how policies change in response to regulatory action. So if you're able to monitor, how an industry's privacy policies are crafted overall, you can actually see how different actions or even controversies, public controversies, affect changes in stated policy preferences, privacy preferences. Is this another tool possibly that could be useful for regulators? And then if people have questions, please, I think there's a mic somewhere in the middle here, and if you line up, and we'll start taking questions. But in the meantime, if anyone has a response to that question.
So I think that sort of tracking practices over time is absolutely useful, would be extremely useful to us. I mean, part of what we do as part of our enforcement program is to continue to look at industries and see, are the actions that we're taking, do they seem to be having an effect within the broader industry? So it may be hard to isolate the effect of one enforcement action on practices more generally, but certainly if there were a way to get at least a rough handle on how policies are changing after an enforcement action, then that certainly could be helpful in determining, whether it would be fruitful to bring more actions like that, or whether we should put our resources elsewhere.
Maybe I just can quickly comment on that. This is a really important point, tracking policies over time, and I think it's something Gwendol also brought up. And we're collaborating with a project called TOSBAC, which is run by the EFF and the Internet Society, that basically has the goal of tracking policies over time and archiving them at the moment in a GitHub repository. So you can actually go back and see what has changed in policies. And what we're interested in is analyzing these changes. So there might be changes that are just not really relevant for privacy, but especially if we want to show this information to users, we don't want to show them outdated information, because that makes us very, that it like basically harms our credibility with the companies if our tool shows old, outdated information. So we really need to keep track of this, and it's one way of how we're trying to do this.
Yeah, just maybe a short reaction to the question. I think it's a great tool for users, for you to understand the way the privacy practices or of a specific company has evolved over time. I'm maybe less, it's a great idea, I mean, but I'm less convinced that it's actually applicable to cases that regulators are actually enforcing on. Because I'm thinking about a specific case that we're working on right now, which is the Google privacy policy, for instance, where we made a number of recommendations on the way to present the information, things like that. And what we're doing is we're assessing for each of the proposals whether or not the company has implemented this in their system. And I'm not sure that in this specific case, which is a specific enforcement action, an automated tool would be useful because, well, we have proposals, we assess whether the proposals are implemented, and sometimes some changes might be very subtle. I think it's very useful if you want to get an overall picture, or if you want to track the privacy practices, or as a transparency tool, if you want, privacy practices of a company over time. Maybe in the course of the enforcement to choose what companies a regulator has to investigate. This is very useful because you make more informed choices when you inspect a company, so that's a good thing. But maybe during the case itself, I'm less convinced that it can be very useful for us at this stage.
Thanks so much. So I think we'll now take questions from the floor. Please, if you'd introduce yourself first, too.
Hello, Peter Craddock from the Liedekerke law firm in Brussels. I think it's indeed, it seems to be a very good tool that you're developing in terms of usability, and so I can understand the importance for users. I also think that in terms of pure enforcement, it may be more difficult because of the specific rules that have to be assessed in each case. But then I did have one or two questions. The first one would be access to the public. So the idea presumably is then that any users could then put a URL, for instance, in the tool and say, is this privacy policy usable? Would that be the idea, or would it be more of a kind of repository of?
Yeah, so the way we're imagining this at the moment and what we're working towards is a browser plugin. So in a first step, you have a plugin you can install, and then shows you for the information for websites that have already been fed through our pipeline, so to speak. And there's also an opportunity for us to then get volunteers engaged. So we can show message like, this policy has not annotated yet. Do you have 1 minute of your time to help us with this? To basically draw engagement with this. So that's what we're looking at. At the same time, I think for researchers and regulators, it would be helpful to have this information also in some type of repository, so that you can access the whole data set or search through the whole data set in a more efficient manner.
Thank you. Then the second question was more about legibility and readability of privacy policies, because presumably it's really about clarity of the information, but do you then also try to take into account things like the use of all caps in a text, because we know that's kind of an import from the US, from the typewriter age, and nowadays basically we have other ways of making text conspicuous and while retaining legibility. And so would that be, for instance, something that you might integrate in there, or that is already integrated? I don't know.
It's a great idea. So there are a couple of metrics that have been proposed to determine the readability of text documents, and that's something that we're also looking at how we can make use of that. Our focus has really been on how can we help the crowd workers make more sense out of the text they're showing them. So we started by showing them the whole policy and asking them questions. Now we're moving to showing them only paragraphs of the policy and having very, very focused questions to reduce the ambiguity that might come from having information scattered throughout the policy that may say different things depending on the context the policy is talking about. So now we're trying to get annotations and extract information from specific instances in the policy, and then we do the work of piecing it together rather than having the crowd worker do it in the head, kind of. So that's one aspect, and the formatting, it's a really interesting point. So what we have noticed is that especially the bigger or the larger companies' websites have really improved the readability. So you have layered notices somewhere. So many companies offer that in some way and provide examples and so forth. But it often makes it also more difficult to really interpret the policy, because what is the complete picture? It's just like one thing here, another thing there, and there. I like the idea of multi-layered notices, but there's kind of like a lack of, there's not really a link between the higher layer and the lower level legal interpretation, and this might be a reason also why some companies don't invest into creating multi-layered notices, because it's not mandated and might get them into more trouble than just having the big privacy policy. Sorry, that went a little bit off course.
No, but that's very nice. Thank you very much.
I'll just add that there's a researcher at New York University. She's an empirical legal scholar who's done work on privacy policies, and what she actually finds is that there is a surprising degree of internal incoherence within the policy. So there's contradictory statements within the policies, not only ambiguity. Please.
I'm very interested, Dennis Hirsch from Capital University Law School. I'm very interested in the part of the proposal that would yield a ranking of different websites or different companies. And this relates to something that came up yesterday in a panel on analogies between environmental regulation and privacy regulation. So in the environmental field, there is something called the Toxics Release Inventory, in which companies disclose how much toxics they released each year. They have to report that once a year. And then the EPA creates a ranking of them. That creates great incentives to reduce the amount of toxics released, and has really changed behavior. And in addition, other members of civil society, different organizations, take those rankings and do their own, make them even more user-friendly. It's up on the web, et cetera. And so I imagine if you guys started with a ranking, other elements of civil society might also do more with it. You would give companies a very strong incentive not to be at the top of the list as having the most confusing policy, which is a good thing. And you might find them changing their policies, and I would encourage you perhaps to have an option for them to communicate either you got it wrong, here's what we do, or you got it right and we've changed it, and here's what we do. And I think through that, you know, a type of disclosure approach, you may actually be able to change behavior. So I'm kind of interested in, how do you foresee the ranking? How would you organize it?
Yeah, I showed this example of the bank privacy policies we looked at. If you search for CMU bank privacy, it should pop up. There we do it for specific data practices, and basically show you what percentage of financial institutions does better concerning a specific practice. And I think something like that might also work for websites. The difficulty with rankings is, so toxic release, that's something that's tangible in some way.
Yes.
And when we talk about privacy, finding a ranking that is objective might be really difficult. So we're looking into that, and we're interested in hearing ideas. And I think it would be great to have something like that, but it needs to be a ranking that makes sense, and also makes sense to the companies that are being ranked, so that they see it as objective and something fair in some kind of way. And you're absolutely right. We need some kind of feedback channel for companies to comment on this. And there might also be the opportunity for this to be somewhat legally binding again. So they could basically provide clarification statements for these interpretations and say, oh, that's not what we mean, this is what we mean, and maybe that could actually become kind of like an addendum to their privacy policy in some way.
Thank you.
So I would just add that objectivity and subjectivity have been at the essence of this entire project. First, starting with expert review of privacy policies. You know, is 3 out of 4 experts enough? You know, is that the right answer? And eventually trying to get to an objective interpretation through the crowdsourcing, right? So in your example, if we pinpointed certain benchmarks to provide a stoplight, if you will, red light, yellow light, green light, we're making the objective, we're establishing the objective standard. Whereas if we have a ranking system, the market plays out, the industry players are ranked against one another subjectively, and then society can kind of make an objective observation about that.
Thank you.
This will be our last question, so please go ahead.
Thank you. So I'm Jean-Pierre Hubot from EPFL Switzerland. I see this project as an extremely promising first step. My question is there a way to go deeper into the companies? Because this is what the companies claim to do. It's not what they do, right? And more companies rely on computers to make decisions. For example, some companies make use of computers to rank applications for recruitment, or insurance companies make use of computers to decide whether to compute, for example, the fee for a given insurance, or a bank will make use of a computer to decide whether they will grant a loan or mortgage or something of that kind. So my question would be to the 3 regulator representatives: do you believe there is space for an investigation that would check whether there is fair use of data in the automatic decisions that are made by companies whenever they make use of algorithms that take as input private data?
Maybe frame that question also as asking, is there a way to kind of match these tools in a way? Can we bring to bear some of the techniques that are being developed here to deal with privacy policies and match them some way with tools that check for compliance or to kind of suss out what's going on in certain automated decisions?
I can take the first swing at that. I'm tempted to say we should postpone lunch for a couple of hours so we can answer that great question, but in just a minute or so, I would say that you put your finger on something that is under a lot of discussion in the U.S. and within the FTC. We had a workshop in September that got into a lot of these issues, and then one earlier in 2014. So I guess I would just outline 2 possible approaches. One is to look at things from the outside, and I think there's been recent work from a group at Carnegie Mellon that has sought to understand or try to understand what's going on within, it may have been Google's advertising system, and I gather that that's sort of cutting edge technical research that's very hard to do. But potentially valuable in sort of illuminating where there might be concerns. The internal approach would involve an investigation, and under the laws we enforce, that could involve not only the FTC Act, but things like the Fair Credit Reporting Act, and certain other laws like Equal Credit Opportunity Act, where there are specific legal requirements in how groups are treated under scoring sorts of scenarios. So I think is very much an emerging issue, but there are some tools that we have to take a look at those sorts of practices.
Yeah, if I may add very briefly, I think the tool is mainly for transparency in analyzing from the outside, but it does not, regulators also need to check what happens actually in the companies, and we have powers for this. We do on-site inspections, we do online inspections, and if there are certain provisions of the law that are not being complied with, then we can adopt sanctions and financial sanctions mainly. we also do some technical work to, and this goes beyond, I think, your tool, of course, to see what types of data are being collected by a specific application on your smartphone, for instance. So CNIL has been conducting a project with Vrije on that topic called Mobilityx. And we published some papers explaining what happens when you're using an iOS device or what happens when you use an Android device. And you can see what types of data are being collected and the frequency of the collection of the data. And it gives you some insights, because basically if you have an application that has nothing to do with geolocation data, to go back to the topic of the previous panel, and then you see, well, they're collecting SSIDs and they're massively collecting SSID, it's a useful indication in the context of our enforcement activity. Now, concerning automated decisions, there's also provisions in the law. I will not elaborate a lot on this because we don't have time, but the systems, to a certain extent, we assess the validity of the algorithms, and there is no possibility to make automated decisions that have legal effects on the people. So the automated tool in credit scoring the systems and things like that are helping the bank or the insurance company to make a decision, but they cannot ban you from the benefit of a right or of a loan or whatever without, you know, having a justification that has been manually checked by a human, actually.
Just briefly to add, I understood your question going beyond, much beyond the project which has been presented here, but we have an additional problem facing scoring mechanisms and algorithms, that the companies using these algorithms are claiming secrecy. There has been a court case in Germany where the highest civil court in Germany actually allowed for this secrecy and prevented a user to learn about the exact composition of her personal credit score, which makes it very difficult for users to actually challenge these decisions. Therefore, the provision Gwendal has mentioned, the actual prohibition of automated decisions having legal effects on data subjects becomes more and more important, because regulators could then argue, no matter what your algorithms is composed of, the way you're taking these decisions is illegal, because there's no human intervention in that decision making anymore, if that is the case. So that's the way forward to answer your question, maybe.
Thank you very much.
We unfortunately have to stop now because I see people are leaving, they're hungry. So really, thanks a lot. I think it has been a very interesting discussion. I'm also very happy that there was some discussion, interaction, also questions from the public. I really hope that we will see like some results of the projects in the next years. So maybe you come again and show us the results of the projects, because people seem to be really interested in this. And for now, I can just say enjoy your lunch. And I hope you're all back at 2 o'clock. Thanks.